Washington, a federal appeals court on Monday, rejected a bid from President Trump's administration to allow the president to fire Lisa Cook from the Federal Reserve Board of Governors, leaving intact a lower court order that reinstated her to the post. The U.S. Court of Appeals for the D.C. Circuit divided 2-1 in declining to grant the Trump administration emergency relief and clear the way for Mr. Trump to remove Cook from her position. The Trump administration is likely to ask the Supreme Court to intervene, but absent an 11th-hour order from the High Court. The decision all but ensures Cook will remain a governor on the 7-member Fed board through a 2-day meeting of its interest rate-setting committee, which Cook sits on and is set to begin Tuesday. Mr. Trump moved to oust Cook from the Fed's Board of Governors last month over allegations of mortgage fraud. Cook denies any wrongdoing. Judge Bradley Garcia wrote in a concurrent opinion joined by Judge Michelle Childs that Cook is likely to succeed in arguing that Mr. Trump's attempt to remove her violated her due process rights. Judge Gregory Katsas dissented. Given that Cook has a property interest in her position, she is entitled to some kind of process before removal, Garcia wrote. Before this court, the government does not dispute that it provided Cook no meaningful notice or opportunity to respond to the allegations against her. The government argues only that Cook does not explain what difference a hearing would have made. Even accepting that premise, Cook's entitlement to process stands apart from whether she would succeed in securing a different outcome. Garcia added that since Cook has continued to serve in her role despite her purported termination by Mr. Trump, granting the administration's request for emergency relief would append the status quo. A Justice Department spokesperson said the agency does not comment on current or prospective litigation, including matters that may be an investigation. The Trump administration asked the D.C. Circuit for emergency relief after U.S. District Judge Jacob ruled that Cook's firing likely violated the Federal Reserve Act and her due process rights. The Federal Reserve Act specifies that the president can only remove a Fed governor for cause. While the term is not defined in the law, Cobb found for cause refers to in-office conduct. Because Cook's alleged misrepresentations on mortgage documents predate her tenure as a Fed governor, Cobb ruled that Mr. Trump lacked cause to remove Cook. The judge issued a preliminary injunction requiring the Fed to allow Cook to remain a member of its Board of Governors during the litigation. President Trump's stated cause refers only to allegations regarding Cook's conduct before she began serving on the Federal Reserve Board. The judge wrote in her decision, adding that such allegations are not a legally permissible cause. Mr. Trump has criticized the Fed for moving too slowly in cutting interest rates, though economists expect the central bank will announce a rate cut this week. If Cook's firing is ultimately allowed, a decision that will likely be made by the Supreme Court, and the president appoints a successor, it would mean he will have appointed the majority of the 7-member Board of Governors. Mr. Trump announced on social media last month that he was firing Cook, appointed by former President Joe Biden, from the Fed Board of Governors and had sufficient cause to oust her. Cook's 14-year term on the Fed is set to end in January 2038. The president cited as grounds for her removal claims made by Bill Pulte, director of the Federal Housing Finance Agency, that Cook made false statements on mortgage documents. Pulte alleged in a letter to Attorney General Pam Bondi last month that Cook claimed 2 different properties in Ann Arbor, Michigan, and Atlanta as her principal residence on mortgage documents from 2021 in order to gain more favorable lending terms. Pulte, who was appointed to lead the FHFA by Mr. Trump, has continued to make accusations against Cook related to mortgage documents. Cook has not been charged with any wrongdoing. Her lawyer said in court papers that she may have erred in filling out a form for a private mortgage, but said the events took place before she assumed office as a Fed governor and in her capacity as a private citizen. Governor Cook did not ever commit mortgage fraud, they wrote. Reuters reported Friday that a loan estimate for property in Atlanta, dated May 28, 2021, showed that Cook declared that residence as a vacation home. Cook filed a lawsuit challenging Mr. Trump's effort to fire her, alleging that the move violated the Federal Reserve Act. While the law does not define cause, Cook's lawyers argue cause constitutes what is set out in other laws shielding officials at independent agencies from being fired at will. Instances of inefficiency, neglect of duty, or malfeasance in office. They said Mr. Trump relied on thinly veiled pretexts in an effort to oust Cook because she has not supported lowering the benchmark interest rate. Tiho's unsubstantiated allegations cannot camouflage the president's real reason for attempting to remove Governor Cook. He disagrees with her policy decisions, Cook's legal team wrote. The Fed said it is not taking a position on whether Mr. Trump's attempt to fire Cook is lawful and said it will follow any court orders. In defending Mr. Trump's move, Justice Department lawyers have said that Congress gave the president broad discretion to remove a Fed governor for cause through the Federal Reserve Act and argued that making contradictory statements on financial filings is sufficient ground for removing her. When governors by misconduct or gross neglect erode the foundations of such confidence, the president acts properly and lawfully by removing them. Justice Department lawyers wrote in a filing to the D.C. Circuit. They argued that the president's power for cause removal is discretionary, and the exercise of that authority is unreviewable by the courts. Justice Department lawyers also rejected the district court's conclusion that the public interest in the Fed's independence weighed in favor of Cook's reinstatement to her role on the Board of Governors. Even with the Federal Reserve's unique structure and history, its governors are subject to removal for cause, and the president's actions to remove Cook based on her misconduct should strengthen, not diminish, the Federal Reserve's integrity, they wrote. Cook is one of several Democratic appointees at independent agencies who have been fired by Mr. Trump since he returned to the White House in January. But her removal is unprecedented, as no president has fired a member of the Fed board in the central bank's 112-year history. Critics of the move have warned that Mr. Trump's attempt to terminate Cook threatens the independence of Fed and, if allowed, the stability of markets and the U.S. economy. Among the other officials Mr. Trump has fired are members of the Federal Trade Commission, Merit Systems Protection Board, National Labor Relations Board, and Consumer Product Safety Commission, who have all sued to challenge their firings. The Supreme Court has allowed the president to oust members of the NLRB, MSPB, and CPSC while their cases move forward, but has drawn a line around the federal. In a May decision, the High Court said the central bank is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. Federal Reserve Governor Lisa Cook can continue to serve as President Trump's attempt to fire her is litigated. An appeals court decided in a 2-1 ruling on Monday. Why it matters. The Fed's policy committee begins a 2-day meeting Tuesday, at which it is likely to cut interest rates for the first time in 9 months. Pending a potential emergency appeal to the Supreme Court, Cook will be at the table. The big picture. More broadly, the ruling suggests courts will act as much of a brake on the president's ability to fire Fed officials. Advocates of central bank independence view the case as a key test of the principle that presidents cannot replace Fed leaders because of policy disagreements or unproven allegations. Driving the news, Judge Bradley Garcia of the U.S. Circuit Court of Appeals wrote in a concurring opinion with fellow Biden-appointed Judge Michelle Childs that Cook was likely to succeed in the case. The D.C.-based judges addressed Trump administration accusations that Cook had committed mortgage fraud, allegations that she denies. Given that Cook has a property interest in her position, she is entitled to some kind of process before removal, Garcia wrote. Before this court, the government does not dispute that it provided Cook no meaningful notice or opportunity to respond to the allegations against her, Garcia added. The government argues only that Cook does not explain what difference a hearing would have made. Even accepting that premise, Cook's entitlement to process stands apart from whether she would succeed in securing a different outcome. Of note, Judge Gregory Katsas dissented. The Trump-appointed wrote in his dissent that the district court judge was mistaken in ruling that Cook has a constitutionally protected property interest in her office. Catch up quick. Cook is serving a term not scheduled to expire until 2038. Trump announced her firing in late August over accusations, lodged by his housing chief, that in mortgage applications on 2 separate properties, she claimed both were her primary residence. The accusation, which Federal Housing Finance Agency Director Bill Pulte referred to the Justice Department for criminal prosecution, has not been litigated in any court or formal process. Reuters reported Friday that separate documents issued by Cook's credit union listed one of the properties, a condo in Atlanta, as a vacation residence. Zoom out. The Federal Reserve Act states that a president can remove a Fed governor for cause. The dispute is over how that cause must be established, and whether issues involving a private financial issue before the appointee took office qualify. Trump administration lawyers argue that the president has broad authority to remove officials based on his judgment that there is cause. Cook's lawyers have argued that if the president alone decides what constitutes cause, then there is essentially no limit on his ability to fire central bank officials, contrary to the design of the Federal Reserve Act. Go deeper. Fed Governor Cook sues Trump administration in fight over firing. Editor's note: this article has been updated with new details throughout. President Trump can't remove Federal Reserve Governor Lisa Cook while her lawsuit challenges his attempts to fire her, a federal judge ruled on Tuesday night. Why it matters. The ruling temporarily settles a question over Cook's status ahead of a critical Fed policy meeting, though the Trump administration has already filed notice that will appeal the decision.